Congressional districts under the U.S. Constitution have to be essentially totally equal in population. How you draw the lines, to a large degree, determines who sits in the seat. If you redraw lines, it's easy, given population changes, to put one or two members of a legislative body into the same seat. So, needless to say, people are wildly interested in this process as to how it affects them. It's always a political process, and there is no way to move political considerations out. Allen is the court's most recent interpretation of how Section 2 of the Voting Rights Act applies in the context of redistricting. Voting Rights Act requires that a minority group have an equal opportunity to elect its candidates of choice. That's the statutory language. Doesn't entitle any group to proportional representation, but it does require an equal opportunity to elect. So Thornburg versus Gingles is the case that provided the framework on trying to determine whether or not a particular redistricting plan complies with it. It's a three-step threshold test. First, whether or not you can physically do it. Can you create a reasonably compact and reasonably configured representational district that's majority-minority? And then, if you have racially cohesive groups, coalesce around a single identifiable candidate. And the third step is whether or not the majority community votes as a block, usually, to defeat the minority preferred candidate. If those three thresholds are met, then you look at the totality of the circumstances to determine whether or not the electoral system is equally open to the minority candidates having an equal opportunity to be elected by the minority community. So Allen versus Milligan is actually the combination of two separate cases brought against the congressional plan for the state of Alabama. Members of the black community and the Democratic Party were unhappy with the congressional plan that was drawn and passed by the legislature. There was some belief that the court might throw out Thornburg versus Gingles altogether or modify it. In fact, they didn't. It was a 5-4 decision. Roberts writes the opinion based upon the totality of the circumstances. The Voting Rights Act required the creation of an additional black district in the state. Alito's dissenting opinion supports the continuation of Gingles' line of analysis, but has a different interpretation on the underlying facts of Alabama. His position is it can't be a reasonably configured district if race was the predominant factor in drawing it. Then you have Justice Thomas taking the position that Section 2 of the Voting Rights Act does not, in fact, apply to redistricting. It's only meant to apply it to other types of election procedures. Allen, I would argue strongly, is a continuation of the court's jurisprudence since Thornburg versus Gingles. Is there a tension between Section 2 of the Voting Rights Act and the notion of a race-blind society? And the answer to that is absolutely. So, and that's an issue that's going to continue for the foreseeable future.